Good afternoon. It's Wednesday, February the 16th. This is the meeting of the Criminal Justice Committee. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Members, I know both Representative Howell and Chairman Doggett are across the hall presenting other bills. So they are here. We've got their stuff in the room. They're just not quite in the room yet. So just wanted to draw that to your attention. Before we get started, we've got a pretty good calendar today, but any personal orders before we get started? Seeing none, we'll move on. House Bill 1833 is item number 1. It's by Vice Chairman Hall. Sir, you're recognized. You have a motion and a second.
Thank you, Mr. Chairman. And members, House Bill 1833 is very simple by design. It's in regard to the disposal of automobile tires in unauthorized areas. Basically, I think what has taken place is the state of Georgia has strengthened their penalties on the disposal of car tires, and which has funneled littering and that epidemic up to Bradley County. Basically, the House Bill 1833 says that if you dispose of less than 4 tires, it's a misdemeanor. 4 tires or more is a Class C felony. And with that, Mr. Chairman, I renew my motion.
Thank you, sir. Members, you've heard the explanation. Any discussion? Any objection to the question? Seeing none, all those in favor of sending House Bill 1833 to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you, sir.
Yes, sir. Next up, item number 2, which is House Bill 1834, also by Vice Chairman Hall. Sir, you have a motion and a second. I see an amendment coded 12856.
Yes, sir, that is correct.
Second on the amendment. Yes, sir, you've got a motion and a second on the amendment. You're recognized.
Thank you, Mr. Chairman. Mr. Chairman, House Bill 1834 is also very simple. It basically says that if a parent of a minor child dies at the hands of a DUI driver, the convicted DUI driver is responsible for child support. This bill takes the shackles off of the DA and the judge, and it does several different things at once. It relieves the burden from the great state of Tennessee. It holds the DUI driver accountable, and it protects our most valuable resource, which is our children. And with that, Mr. Chairman, I renew my motion.
Members, you've heard the explanation of the amendment. Any discussion? Any Representative Dixie, you recognize?
Just one quick question. How would the child support be calculated?
You recognize.
Or restitution, I'm assuming.
Chairman Dixie, I left that at the discretion of the judge. Hopefully in the future there's a formula in place, but right now I'm under the impression it's going to be handled almost like a divorce settlement agreement, where child support there's a formula and it's a percentage of your income. So it's not a one-size-fits-all.
Thank you.
Chairman Dixie.
Thank you.
Okay. Any other discussion? Seeing none, any objection to the question? Seeing none, all those in favor of adopting amendment coded 12856 to House Bill 1834, please signify by saying aye. Aye. Those opposed, you adopt. Members, the amendment made the bill, but do you have anything to add, Mr. Sponsor?
No, sir.
Okay. Seeing no objection to the question, we're ready to vote. All those in favor of sending House Bill 1834 as amended to Calendar and Rules, please signify by saying aye. Aye. Those opposed? Sir, you had to Calendar and Rules.
Mr. Chairman of the committee.
Yes, sir. Thank you. That brings us to item number 3, which is House Bill 1767 by Representative Gillespie. Motion. Sir, you have a motion and a second. Sir, I also see an amendment on this coded 13291. Got a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee.
Question's been called on the amendment. Okay. Without objection, we're ready to vote. All those in favor of attaching amendment coded 13291 to House Bill 1767, please signify by saying aye. Aye. Those opposed, you adopt. Members, the amendment made the bill. Any questions on the bill? Chairman, okay, withdrawn. Chairman Dixie, you recognized.
Thank you for withdrawing that. I appreciate that. A quick question. I'm just not clear. I'm sure my representative up there probably knows the answer to this. But what is the current recommended sentence for aggravated robbery right now?
Representative Gillespie, you're recognized.
Thank you, Mr. Chairman. Chairman Dixie, I believe right now it's a Class C felony, which is anywhere from 3 to 15 years. I don't know if that answers your question or not.
Chairman Dixie.
It does. So what would this bill change it to?
Representative Gillespie.
Thank you. So it would basically force you to, if convicted, for that judge to sentence you to at least 85% of that. There's no early release, which is the problem right now is we have a lot of people that are committing aggravated assault and aggravated robbery and in and out of the system very quickly and then committing other crimes such as murder or rape.
Chairman Dixie.
I don't know if you can hear me over the reunion that my colleagues are having over here,
that's right.
but just one last quick question is, so it still keeps in the context, the judge still have the range from 3 to 15 years. It just would have to be 85% of whatever the judge sentenced them to. I just want to be clear.
I just want a point of clarification. I'm being told it's actually a Class B, which is 8 to 15. So 8 to 30, excuse me.
8 to 30?
That's
So-
current law.
So does the judge have the discretion, still have the discretion to do it from 8 to 30? You're just saying that if he says 8 years, it has to be a minimum of 85% before you are eligible for release.
Yes, sir. That's my understanding of the legislation. And Representative Griffey, you may have something to add to that. But Gillespie, you may have something to add to that. But
Thank you, Mr. Chairman. Yes, that is my intent. My intent is that what the judge says, you're serving that full term, and there's not that sentence of 5 years and you're out in 6 months.
Thank you, Chair.
thank you, sir. Any other discussion? Seeing none, we're ready to vote. All those in favor of sending House Bill 1767 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance. Thank you. Yes, sir. That takes us to item number 4, House Bill 1025 by Leader Lamberth. Second. Leader Lamberth, I see you have an amendment coded 13424. Do you wish to move forward with that? Second. You have a motion and a second, sir. You're recognized.
Thank you, Mr. Chairman. If we can get the amendment that is, I believe, a combined amendment from the amendments that were on and put on in the sub, if we can get that on, and then if I could be recognized to describe the bill as amended.
Certainly. Question's been called on the amendment. All those in favor of attaching amendment coded 13424 to House Bill 1025, please signify by saying aye. Aye. Those opposed? You adopt, sir. We're back on your bill.
Thank you, Mr. Chairman. And members, the fiscal note on this is probably the most instructive of exactly what we would accomplish if this bill were to become law. And I gave a relatively lengthy description of this in the subcommittee. I will not repeat that just for purposes of time today, but obviously we'll answer any questions anybody has about this. This has been the product of really about a decade's worth of work and comes from sitting on multiple task forces, having hundreds and hundreds of conversations with both those that have served time in correctional facilities, those that have had loved ones harmed or killed by someone who is serving time in a correctional facility. I've gone to multiple different parole hearings. I mean, it's just task force after task force has been appointed on this, and it really boils down to this. In 1989, when our current sentencing structure, and this is the current structure, was set up, it was set up because we were under a federal lawsuit for prison overcrowding. And we established, we being the legislature, none of us were here at that time, a structure that looks tough on crime on paper, and then it really relies upon TDOC and the parole board to manage their population in a way that doesn't get overcrowded. I mean, that's the basic structure that we're under now. That doesn't make any sense. Not from a community safety standpoint, not from just a basic fairness standpoint for the inmates that are inside a correctional facility. What would make sense would be something along the lines of this bill, in my humble opinion. We had fiscal review work with our legal folks, legal department, and with TDOC and AOC to figure out how long are people really serving. And this bill exposes that. It is a tiny percentage of what the sentences that are actually being issued out by a judge. And when a judge gives somebody 10 years to serve, it's 10 years to serve at 30%. So, I mean, like, nobody really hears the percentage. I whispered it there for effect, obviously, but what people hear is the 10 years, both the defendant and the victim and their families. I mean, that's what they're hearing is 10 years. For a defendant, and I spoke to one gentleman that actually emailed me because he couldn't stand the bill, hated the fact that it was called Truth in Sentencing, thought it dealt with mandatory minimums and a bunch of other stuff. He had served time at a correctional facility. I emailed him, asked for his number. We had a wonderful conversation. Once he had reviewed what the bill actually does, he said, yes, absolutely, I'm in favor of that, as someone who had served time in prison. He said when he went in this particular circumstance, I believe he told me he had a 27-year sentence at 30%, okay, over a theft-related offense, obviously a very large theft. And all he heard was 27 years. He assumed he was going to die in prison. Now, in the subcommittee, I highlighted how horrible it is for victims to have to go before a parole board over and over again. Just for today's purposes, I want to highlight looking at it from the other side. When a defendant has been committed to a prison and they've been ordered to serve by an elected judge a specific sentence, and they hear 27 years, they lose hope. I mean, there's not a whole lot there to look forward to. I mean, you're going to be in prison for the remainder of your young years, if not your entire life, depending on what age you are. Even if it's 30% eligibility, take 10 years, for instance. Many 10-year sentences can be up for parole in as early as a year and a half to 2 years. That doesn't mean you're going to make parole. So that first parole hearing, what that inmate has to do is, for most purposes, they're going to try to get a letter from somebody outside or multiple letters saying, hey, here's where they're going to be living. Here's where they're going to be working. Here's somebody that's going to vouch for them. They're going to get folks to testify in front of a parole hearing. And many, many, many times they're going to be denied parole the first time around. So everybody gets all geared up for their son, daughter, husband, wife, family member to come home from prison, a prison sentence they got, a 10-year sentence at 30%. They get all worked up about it and try to get, that person out on parole, and they get denied. Well, a year or 2 years down the road, they try it all again. Then they get denied again. By the time they're up the third time, the whole family's given up on the process and pretty much given up on hope because we got denied 2 other times. Maybe this time will be the time that they come home. And it all depends on the personality, quite frankly, of the parole board, the folks there before, and just kind of what's going on in the world at that time. And if you don't believe me, just talk to some of the folks that have been on the parole board over the years. They do a very good job, but they're people. And they do the best job they can. But if there's somebody that's coming up for parole, and most would not necessarily admit this, but you can see it happen in the parole grant rates. And there are several types of one specific crime in the news over a span of months. You can watch the parole rates drop of the individuals that are up for parole in that specific type of crime. These people have already been sentenced. Why should they be resentenced again by the parole board? Shouldn't they be able to know on the front end what their sentence is going to be? And the last thing I'll leave you with, this bill also changes the way we look at prison. It has a work release program built within this. And that's just the tip of the iceberg of what we could do if somebody comes in and they know when they get a sentence, if it's 3 years, that it's 3 years at 100% with 1 year release at the end of that. And if they do the program, if they utilize work release or treatment programs or mental health programs while they're in, that's the date they're getting out. The entire system can then program and plan for that date. Not some amorphous date that some, board of people somewhere might give them, but that specific date, and get folks on a plan to success so that hopefully they don't reoffend. It's a big bill. It's a lot of years in the work. But, Mr. Chairman, that is basically what the bill does, and I stand ready for questions.
Members, you've heard the explanation of the bill. Any discussion? Okay. See, Representative Beck, you're recognized.
Thank you, Mr. Chairman, and thank you, Leader, for attempting this hard slog on this. As I stated in sub, I have ideas that this might, if I was a criminal and I was in jail right now, or in prison, I should say, and right now, you work to better your life. You work to get on programs. You work to really, start framing your case, so to speak, for the parole board, and that I'm getting my rehab. I'm getting the things that I need to be a good member of society. And with your proposed legislation here, that is taken away, and you have put in the 1 year of good, if you're don't get into any trouble, have a clean record, then you have 1 year of work release, basically. Or privileges, I think you term it. Or how do you term it? Let me go back to that.
Leader Lamberth, you recognize.
What this draft has done, and so the work release I mentioned is actually, and I know it's kind of hard to think about this in prison in this fashion. Work release would be during the incarcerated portion of their prison time. So if someone has 3 years at 100%, they could potentially be leaving the prison walls during that time period. Now, we're only talking prisoners that fit very strict criteria, very low level risk. But these folks are doing programs like TriCor and other programs inside the prison walls now. We have jails that have really good work release programs. For lower level offenders, there's no reason why during the time period that they're incarcerated, they couldn't actually have work release. It has worked well in other states and other areas. It can and I think will work very well for us. And I have other confidence in TDOC to be able to manage that so that it's only those folks that are. So the work release is part of that time that they're incarcerated. The good time credit, for lack of a better word on this, that is built in during the percentages now, that it's a moving target every month. I mean, it depends, and it almost depends on the whims of kind of the staff at the facility you're in as to whether or not you're getting that good time, and it's very difficult to kind of determine. But that good time is built in automatically to this bill. So if someone gets a 5-year sentence, it's 5-year sentence suspended to 4 years at 100% to serve with 1 year on supervised release. So the parole, as we know it, is literally built into this bill, and it gives TDOC the absolute authority to be able to allow that to be a moving line dependent upon their behavior. So instead of assuming that every prisoner is going to be bad and not do programs, this bill assumes that they're going to do programs. And if they don't, time can be added into their sentence. And I was having a conversation with a gentleman earlier today, and we were discussing this very thing. The hope would be if somebody has a 4-year sentence, let's say during the first 2 years, they do absolutely nothing, which many prisoners now will do. They will say, look, I'm not interested in programs. I'm not interested in parole. I'll just take my time. I'll take it to the wall. Let me out when you let me out. I'm not doing any of your stuff, okay? They can still get some good time just for not getting in fights or whatever else. This bill says, instead of assuming everybody's going to be bad and rewarding those few that might be good and go above and beyond, this assumes that we're going to have a valid program that everyone should follow. And if you don't follow it and say the first 2 years do absolutely nothing during your time could be added onto your sentence during that 1 year supervised release. And say 2 years in, you see the light, and they'd added 6 months out. So within that 5-year sentence, you got a 4-year sentence at 100% with a year to serve on supervised release. They've added 6 months to it. So instead of get out in 4 years, now you're getting out in 4 years and 6 months. You get closer to that release date that you thought was 4 years had you done the program, and you start asking around, hey, how can I get my 6 months back? And start doing programs, they can then reduce that time back down, but only to the 4. So what it does is it builds the good time into the bill, but in a very certain way, and it also gives TDOC the ability to be able to manage that instead of an outside entity in the parole board. So the folks that are working with prisoners every single day on the programming, the ones that know them the most and the best, those are the folks that are actually making that determination, but only within the year.
Representative Beck.
So TDOC cannot lengthen someone's sentence. They can just, if I get a 10-year sentence or I get a 3-year sentence, there's only 1 year that can be good time?
Yes, sir.
Is that correct?
Yes, sir.
Okay.
And we have lowered the sentences on paper. Again, this structure here, it doesn't work. If you raised every single one of these sentences up to 100%, the fiscal note is in the hundreds of millions. I mean, literally 600 to 700 million, because this was never designed to be a 100% sentencing structure. It was designed to be very bloated on paper with very low release percentages by definition. I mean, because they had very high sentences. That's how they got prison overcrowding. This bill literally takes those sentence ranges down to where they are now, to where the average that folks are serving right now. And it just is honest about it. I mean, that's the reason the fiscal note over a 10-year time period saves approximately $25 million, because there's no parole. So all of that expense and everything that goes with parole would be savings in this, but there's also not great expense with this bill. The fiscal note, because of the way we calculate them, I think comes in at $10.9 million because we have to calculate the most expensive year without any savings being calculated. So in the year that it actually costs $10.9 million, it saves 19.7 because we've created a more streamlined system that's certain. So, sorry, I hope that answered your question.
Representative Beck.
That did. So after the terms that are before your legislation would take into effect, after those are served out, then the parole system would sunset. Is that correct?
Yes, sir. It wouldn't sunset. I mean, the parole board has a role beyond just determining whether or not someone will be released. I mean, they do handle other types of hearings. I mean, so this wouldn't be the only reason for them. So there could be a truncated purpose for them to be there. But their primary duties now would definitely be wound down, and we don't sunset them. We don't technically do away with the board. But yeah, I mean, their role would be greatly diminished, and I would argue that over time we would probably shift the majority of their resources over to TDOC that's actually managing the population.
Representative Beck.
Mr. Chairman, we've talked a lot about TDOC and their role in this, and I see that they're here today. Could we go out of session and let's ask them some questions about how this would work? If they're prepared.
Unfortunately, they're not on the list to testify. They've not asked to testify on this. So for our committee rules, they would have to be on the list to testify.
Okay. So we can't call up any legislative liaisons to testify?
That's right.
Okay.
Leader Lamberth.
I will say, while I don't know that they have any specific stance on this bill one way or the other, I mean, I don't know that it's been flagged one way or the other. I have had conversations with lots of folks within the different departments of state government and tried to take in unofficially. I mean, because again, officially, this is, a bill that I have sponsored. This is not a department or administration bill. This is a bill that,
Right.
I've worked on for years. But I have tried to listen and learn from folks, both within TDOC, parole board, everyone else. I mean, they've been on many of these task forces. So while they are not here to testify today, there lots of things have come from those conversations over the years that are embedded within this.
Representative Beck.
And I appreciate your indulgence, but, okay, drug crimes, there's not going to be any, is there going to be flexibility for the judges to send them to in our drug courts and things like that, to send them for rehab and to send them to for programs that will help them re-enter a productive society? Or are we just sending them to jail?
Leader Lamberth.
Great question, and thank you for asking it, because this actually enhances and enlarges the population that would be eligible for probation, because by putting these sentence ranges down to where they really are now, judges would have more discretion on whether or not someone would be able to go to probation and do a rehabilitation program or have a sentence to serve. And then we allow for all of those programs that are within TDOC, and I hope that we continue to encourage and fund more programs that are available to them. But nothing in this would take away from those programs. It would actually add to the number of populations, because those sentence ranges are right-sized. So right now, any sentence above 10 years is a to-serve sentence. Some of these sentences, folks are not serving 10 years. So if instead of having, again, a 21-year sentence at 30%, you're bringing that sentence range down to where it really is now. And so folks that would not be eligible for probation would be eligible. Doesn't mean they're going to get it. That's up to the judge. But right now, that judge's hands are tied with anything that's over 10 years. So if there's a sentence range that's outside of 10 years right now, under this structure, then you go to prison. Like, you do not have the opportunity for probation.
Representative Beck.
One last question. Do we anticipate having to build any more prisons under your proposal?
Leader Lamberth.
No, we do not. However, I will tell you that additional facilities, regardless of what you want to call them, because again, in my opinion, it would be better if we took a deeper dive and look into what our prison system looks like. Right now, it's like a light switch. You're either in prison or you're not. We do vary slightly some of the conditions of your imprisonment, but for the most part, you're either in or you're out. You're either on probation or you're in prison. Long term, it would be a really good idea to look at our facilities and design them around the programming that's actually available. So while no, we don't need an additional capacity through this, we just in a budget hearing yesterday had a discussion with TDOC over how much money is spent on the current prison system that we have now, how much has been reverted back, and at least had a conversation of, are there facilities that would serve the population that we have better? I think that there are facilities that could be designed that would really meet those programming standards that we've all talked about in here, but the current prisons are difficult. For instance, just work release. It's very difficult to have somebody on work release in a traditional prison setting, just from them coming in and out of a prison that is a very traditional lockdown secure facility. If you're going to have folks on work release, just like the local jails, you're normally not going to want those folks to mix back in with the rest of the population on a regular basis. It creates a massive security risk. Our prisons, as we have them right now, it's difficult for them to be able to do that. Not impossible. So long answer to a short question, I apologize. But while this bill does not envision needing additional facilities, I personally feel like in Tennessee we need different facilities that potentially could be new facilities because of the program that we have available.
Very good. Thank you very much.
Thank you, sir. Next on my list, I have Representative Campbell.
Thank you, Mr. Chairman. My question rotates similarly to what he discussed there, state prisons and their capacity. Do you know how many offenders are anticipated to be spending more time in prison based upon your legislation? And also, there's a line that concerns me very much in the fiscal memo, and that is regarding, well, it says the following: however, due to unknown factors, including the capacity of existing facilities. Those are among the reasons that they have difficulty giving a precise fiscal impact at this time, even though they've given you some very specific numbers. But my concern is with the staffing shortages we've seen in my region and others across the state, we could be setting ourselves up for a problem, and that is my only hesitation here. Thank you.
Leader Lambert.
So if pages 4, 5, and 6 of the fiscal note go into great detail to that exact question. And again, trust me when I tell you, I have spent literally days with fiscal review and our legal and our extraordinary lawyers to try to get to that very question, because the goal of this legislation is to neither drastically increase or decrease the sentences that are being served now. It is to drag those sentences out into the daylight and make it transparent as to what they are. So if someone was serving, on average, a 3-year sentence under this current sentencing plan, so let's just say hypothetically that a 10-year sentence at 30%, an average number of people were serving 3 years. It's not that, by the way. But what this bill would do is would make that a 3-year sentence with 1 year on supervised release. So a 4-year sentence, 3 years at 100%. So you see what we've done there to ensure that we're not increasing the number of prisoners that we have. We've made this the average of those sentences that over the last 10 to 15 years they were able to calculate. So it neither drastically increases nor decreases the number of prisoners or time that they're serving. It reflects the time that they're serving now in a better fashion. Now, the line in there about facilities is a relatively common note to see in the fiscal note. Some of that, from my understanding, deals with the fact that it's hard for us to understand and predict what crime patterns may arise. So there are crimes that, that will kind of rise and fall as to the propensity of the population to commit those crimes. So it is very difficult to say, here's exactly what the next 10 years is going to look like, but the numbers in this bill are based on what we've seen in the past, and the best predictor of future performances is really past behavior.
Representative Campbell.
Thank you. On page 6 of the fiscal memo, it lists a number of offenses. Will you translate this for me just a little bit? Is it telling me that some of these offenses will be serving less time and others will be serving more?
Leader Lambert.
That's exactly what it says. Now, again, small amounts one way or the other, not large distinctions. But, I mean, just look at the top line, aggravated assault resulting in death. There's a very small number of admissions there, but it's 2.8 admissions. The average time sentenced was 7.8 years. The time served was 3.09. And so the estimated sentence on this is 5 years. There's a fiscal note of $42,500 because there would be a tiny tick up in the amount of time that those individuals would serve. It's almost impossible to get it perfect. I mean, there's small dips one way or the other when you try to design a bill that accurately reflects the average time served. And so, yes, on some of those, again, it could be a little bit down or a little bit up, but the goal is that it's going to be pretty close to that median.
Representative Campbell.
Thank you. This is my last question, and I'm hesitant to mention it, but the highest percentage decrease is continuous sex abuse of a child. I don't know how they came up with that, but that blows my mind. Of all the specific offenses, am I misunderstanding something?
There was
Leader
one
Lambert.
admission. So that one's very difficult to kind of figure, and the reason the percentages, so the larger number of cases that you have within any category, obviously your changes are not going to reflect as much. When you just have one case, the estimation on that percentage-wise is going to look very different. So
That information makes me feel much more comfortable. Thank you.
Representative Griffey, you recognize?
Thank you, Mr. Chairman, and I'll try to be brief. Look, I support this legislation. My criticism is, the sentences probably aren't long enough. It's what we need them. But I recognize the fact, as I think Leader Lambert does, that the only way we're really going to get the public to recognize and appreciate where we are at prison sentences in Tennessee is to have truth in sentencing. So that's first and foremost. And I'm going to support it on that basis alone, and I advocate that we take a serious look at the offenses and the level of incarceration for some of these offenses, because first and foremost, we need to protect the innocent citizens in Tennessee. I did want to mention about the facilities and so forth. I used to be Assistant Attorney General for the state of Tennessee. I visited every single state prison in the state of Tennessee in that job. I've also been an Assistant Federal Public Defender. I've visited just about every CCA facility there are. I know people have criticisms of the CCA facilities. I will say this, CCA can perform a very valuable function in their institutions from my experience, and if we can start getting facilities located to near our manufacturing centers so that low-level folks can get out and work in manufacturing if they deserve it and want to. To me, an idle mind and hands is the devil's workshop. And if we can keep people busy and get them working, when they get out, they've got a job and they've got some resources, and that's the best way to get them back in society and give them that opportunity anyway. So thank you very much, Leader Lambert, and thank you, Chairman.
Thank you, sir. Leader Lambert, you recognize?
And thank you for those comments, and I want to kind of combine two answers here or one answer to two different questions. Like aggravated burglary on this list, they estimate it's 118 admissions. The time that someone's sentenced to on that is 8.3 years. The time served is 3.7. This would actually go up by about 0.4. I can tell you right now that on continuous sexual abuse of a child, on aggravated burglary, on several of these crimes that are on here, when you look at this list, several of these crimes, folks are not serving anywhere near what they should. Now, look, that is a project for another time or even later in this session, but this, I hope, exposes what this hides. Because when you look at this list, or if you look at, an aggravated burglary, and you hear in court that they're getting 8.3 years, I mean, let's just say somebody's getting a 9-year sentence. Well, that sounds pretty good. I mean, it's like, okay, they burglarized someone's home, they violated the sanctity of that home, they got 9 years to serve. Well, when you know they're coming out in 3.5 years, that kind of is a different scenario. So exactly what you just said, I hope is what this exposes, regardless of where this goes. I hope it would pass this committee. But, I mean, several of these sentences are too low. I will tell you that when you look at the full list of every felony, and we had fiscal review break it all down. I mean, it took a long time, and I really appreciate our attorneys here in the legislature and fiscal review working on this. There are some of these sentences that would surprise you are probably too high. Now, I mean, but it's all hidden because it's all hidden with percentages. The year gets set in court, and then it's 30%, it's 85%. I mean, I hope we continue to look at all of this and, quite frankly, raise several of these sentences in a different bill and even potentially lower some. But that is a conversation for another day. This just exposes where it is.
Okay. Representative Dixie, you recognized?
Just for clarification purposes, most time when someone's sentenced to prison or they can commit a crime, most time it's more than one offense. How does that impact it with this? Because sentences vary for different offenses. How would that be handled by the judge?
Leader Lambert.
Again, great question. The exact same way it is now. So we leave all of that discretion in our judges' hands. There are other statutes that deal with, whether or not something should be consecutive or concurrent, or run on, together or one after the other. All the percentages and ranges, we don't touch any of that. It's literally it's that percentage of time that we're looking at. So we don't go into the equation of whether or not something should be concurrent or consecutive or even how they fall within the ranges.
Representative Dixie? Okay, thank you. Members, we do have Jeremy White on the list to testify. If Mr. White is in the room. Sir, you can come forward. So members, without objection, we are going out of session. Mr. White, as you make your way to the front of the room, you can either stand at this podium or you can sit at the table. And if you choose to stand or sit, either one, there'd be a button on the microphone in front of you that looks like has a picture, looks like a voice talking. If you'll press that, if the red light is illuminated, then it's on. And if you could please state your name for the record, and if you represent an organization, let us know that, and then share with this committee whatever you'd like. And you have 3 minutes is the time, and then we'll have unlimited time for questions if members have questions for you. So you're recognized, sir.
Thank you. My name is Jeremy White, and I'm a fellow and a trainer with Free Hearts, also a representative. They're an organization that has helped me during the reentry process. I did 22 years in prison. I went in when I was 19. I came out when I was 41. And I did time at 100%. I was charged with especially aggravated robbery, criminal attempt first-degree murder. My sentences were ran concurrent for one 25-year sentence, and I did 22 years in the Tennessee Department of Corrections. I laid down last night thinking that this bill was a one-pager, and then when I read the amendment, I clearly was wrong. It was 33 pages, and I apologize for my rugged look. I thank you for allowing me to be here to speak. I came here today because when I met with Lita Lambert and I was trying to understand the purpose of this bill, I had to kind of think back about what I went through when I did time at 100%. And I can assure you that individuals inside the Tennessee Department of Corrections that are doing time at 100%, number one, the sentence reduction credits mean everything. The sentence reduction credits, despite the fact that I had 100% and had 3 years shaved off of it, meant everything to me. It meant something to me because I was able to go into programs that I typically would not have been able to go into in the Tennessee Department of Corrections because of my class and level of offense. Also, as I looked at the bill and I kept reading it, and I said, well, Lita Lambert is really championing a bill because we do need sentencing reform in this state. But the bill did not have balance. It had a lot of substance to it. It was really good in areas that I felt were meaningful in terms of trying to redirect sentencing in the state. But as it relates to balance, there are individuals that are getting time at 100% inside of the Tennessee Department of Corrections. And if you just hear me out, if you maintain 100% for everyone, Lita Lambert, any class felony coming in with no percentage, no sentence reduction credits, that is going to create the most volatile, violent, and unpredictable environment inside of the prison system that you can imagine. It's already violent. It's already understaffed. You already have facilities that don't have any control. And I've been in them. I've been there. I've been at war in prison. I've trafficked drugs in prison. I've seen what can happen when facilities are understaffed. I've seen what can happen when the administration of facilities don't know how to adequately run their facilities. And I've seen core civic facilities. I did 6 years at Whiteville Correctional Complex, 6 of my life in that facility. So I just wanted to come here today because I do believe in what Lita Lambert is doing, but I feel like that there needs to be a balance. And if the committee is going to review this bill and they're going to hear it, then they need to make sure that if you're going to remove anything from these men and women that are going into prison, think about that, because you're taking away something from them, even though there are programs that already exist. The 100% time that I had to do, it was because I did what I did. I had to take accountability for what I did. I did that. I met with the victim. I made amends. I did my time. I've been proactive, and I've come out. I graduate this summer. I have a great job, and I'm just really standing here before you today because I want you to think before you pass this bill. And that thinking is to say that if you commit someone to the Tennessee Department of Corrections, Leader Lambert, at 100%, no matter what class the felony is, you are layering oppression on top of oppression. And for the most part, for me, a person that did time at 100% again, it's hard to come back out and transition into society. And then when I went further and read the bill, I saw that if you messed up in prison, that you might have to do 1 year of extra supervision outside of the time that's already expired. I didn't understand that. Maybe I misinterpreted it, but I read the bill. As
Mr.
it
White,
relates,
Mr. White, I apologize. Our time just for your comment period is up, but we have unlimited time for questions, and I do
Okay.
have some folks on the list who'd like to ask you some questions. So,
yes.
yes, first I'll go to Leader Lambert since your name was called, and then I also have a list going.
Jeremy, thank you for being today, and I enjoyed our visit in the office, and I know you've not had a chance to review the whole bill.
I have.
So,
I read it.
it's okay, I know, but you said it was one pager and then 33 pages, so I'm not trying to got you here.
Right.
But I know I shared with you in the office, and I know it comes as no surprise to you that there are folks that have served time in prison that have a very different perspective about the structure of this bill, because it gave them structure and certainty, okay, the type of things that you and I discussed.
Right.
Your sentence was very different, and obviously this doesn't change what you went through. But for those that are getting 30% sentences and go before the parole board multiple times, and we talked about this with the other gentleman you were with there in my office, and hopefully you admit that while it doesn't change your circumstance, but to have a specific sentence with 1 year of supervised release, and it doesn't add on more supervised, it, depending upon what you're doing in the prison, it can either increase up to that 1 year, how much time you serve, or potentially keep it at that date certain. And so I don't know if you want to comment on that at all. I know you shared some things with me in the office about how it's helpful for folks to have a date certain that they can work towards. But that's what I've tried to design into this, is to make sure that folks do have hope and they know when they're going to come out so they can do those programs. You had that because you had 100%er. You only got a small amount of your time that was off, which is, quite frankly, similar to what we've done here, because it's got 1 year at the end there where folks can work toward that. As long as they do the program, they get automatically that 1 year. And I think the other gentleman we were meeting with was quite excited about the fact of not having to go before a parole board, because you heard my description earlier of how difficult that is for both defendants, their families, and victims and their families. I don't know what your thoughts on that are, but I did enjoy our visit in the office, and I thank you
did.
for being here today.
Yeah, so
Mr. White?
I appreciate that, Leader Lambert. Let me say this again, substance, not balance. The reason why I say that is because the bill does have substance, Leader Lambert. And the thing that I just want to continue to mention is that it needs to have balance. In other words, when you're taking the Sentencing Reform Act and repealing it and replacing it with this bill, every class of felony, from what I understood in the bill itself, would serve 100%. The transition time, to me, wasn't really a factor, because for me, serving time at 100%, I didn't have any transitional period time, and I thought that was really a great idea, because men that serve time at 100%, and let me just add to that, you do not know what's going on with these men mentally, number one, and for me, the fact that I stayed with a mental health specialist in the Tennessee Department of Corrections for 15 years and worked with them prior to getting out, I can assure you that, Leader Lambert, looking at the fiscal note, from a mental health perspective, men and women that are doing 100% in lengthier sentences and maintain oppression, the state of Tennessee is going to be spending a lot of money. And I understand that Leader Lambert is bringing this forward in relation to that. I felt you, Leader Lambert, and I understood you because you're someone that's championing this bill, and it needs to be done. It just needs to be done in a balanced way.
Thank you, sir. I do have, next on my list, I have Representative Hawk. You recognized?
Thank you, Mr. Chairman, and thank you very much for being here. It takes some courage to get up in front of this bunch and talk. I get scared every time I talk to this bunch, so I appreciate the courage that it takes to come up and tell where you've been and where you are now. So I really appreciate that. And just a little point of clarification for you and others as they're watching. As you call Mr. Lambert's name, Leader Lambert's name, it is a bill presented by Leader Lambert, but it is going to be a work of this legislative body. So as we call out individuals for the work that they're doing, there's going to be 99 of us here in the House and 33 in the Senate that are going to be having a hopeful say-so in this as we put this product together. Tell me a little bit about behavior. And I see where we're going with this piece of legislation, that we're talking about, all right, you're going to start with XYZ, and that's the end date for you. And if there is bad behavior, if you don't do your classes, if you don't do it, then we're going to add 3 months, 6 months, 12 months to that. Your initial blush reaction tells me you don't think that's an effective way to improve behavior in a prison setting. Tell me a little bit more about that.
So when
Mr. White, you recognize?
When you eliminate the sentence reduction credits and you create a structure that sets a set expiration date, 100%, it almost de-incentivizes good behavior. For me, doing 22 years, I met a lot of men and women that acquiesce to the prison lifestyle. Some people, for whatever reason, make their own choices. I had to make a lot of choices in the prison setting that were tough. As it relates to my behavior, what was able to help guide me was the fact that I was able to get sentence reduction credits off the back end of my sentence, so I wouldn't have to do the full sentence. And not just that, that allowed me to go into programs, because typically individuals with violent offenses are not allowed to go into programs into the Tennessee Department of Corrections based on your classification. There's specific offenses that they're just not going to let you do it. They're not going to let you go to work release. They're not going to let you participate in a minimum restricted facility. In fact, you can't even get to a minimum restricted facility depending on what your offenses are. So that's really a smaller portion of the prison population. And the larger portion of the population, they have violent offenses. And so if we're really going to curtail that, we need to focus on that behavior. That's just what I'm trying to present.
Representative Hawk?
And thank you, Mr. Chair. I've got a lot of ideas swimming in my head right now. I'm going to pause and allow you to go on to the others, potentially come back to me, but I want to think on that for a little bit. Thank you, Mr. Chairman. Thank you so much for your
You're welcome.
Thank you, sir. Next on my list, I have Representative Lamar. You recognized?
Thank you, Mr. Chairman. So my question is, and I just want to be clear, are you saying if we pass this and take away those credits, do you think violent crime or violent occurrences within the prison are going to increase as a result of taking away these sentencing credits? Do you think that more bad behavior is going to happen within the prisons?
Yes.
Mr. White?
That's all I wanted to know. Thank you.
Thank you, Representative Lamar. Next on my list, I have Chairman Holsey. You recognized?
Thank you. If I understand it right, all you're doing is saying before you were told you're going to serve 8 years, but you really served 3.5. So what we're doing is for 8 years, we're calling it 3.5. So this bill says since 3.5 is what you've been serving, that's what you're going to serve now. You're just going to serve 100% of the 3.5. Is that correct?
Leader Lambert?
This, and to the presenter's comments, and again, thank you for being here and deeply appreciate you stepping up and testifying. As I told you in the office, your perspective is very important to us, just like lots of other folks. The good time is not taken away in this. I can't emphasize that enough. Now, I understand the way you have experienced good time would change. The 3.5 years, absolutely, that's what you would serve, with a year of supervised release where the good time is automatic. You get the good time. We are going to assume folks are going to be good. If they're not, they could have sentences, they could have time added on up to the year and taken back down again if they got back into programs. That year is there as that variable that TDOC can utilize as not only good time, but something that flows up and down depending upon whether they're doing the programs, whether or not they're actually doing what they should within the prison walls. The good time's automatic. It's not taken away. It's just structured in a way that it's clear to everybody. Every single month you were serving, you had no idea whether or not you were going to get your good time that month or not, and your out date shifted probably hundreds of times in the time that you were in. For yours, actually, I should say that different. You had 100% or so. It may not have for yours. In most sentences, it will, because it just varies per month on what that good time is. This builds that good time in where it's 1 year of automatic good time. That's 1 year of supervised release at the end that can fluctuate up and down whether or not you are actually doing the programming that you should be doing in prison and behaving yourself. I mean, if you're doing what you're supposed to be doing, you automatically get it. You don't have to go before a parole board. You don't have to have anybody else that will grant it to you. It's built into the structure of the bill. So I want to be crystal clear. You've said several times taking away good time. This bill simply doesn't do that.
All right, members, I just want to remind everybody, we're out of session, so these questions should be directed at our testimony here, at our witness. Representative Hawk, you mentioned to come back. Okay, he passes. Members, that exhausts our list for questions for the witness. Does anybody else have any? Seeing none. Mr. White, thank you. You and I know each other, and I've always enjoyed getting to talk with you, and I think what you had to share with this committee is invaluable, and I know everyone here is thinking about it. And it is certainly influencing what will be the ultimate and final product of this legislative process. So as Representative Hawk stated earlier, today is not the final, chapter in this book. I mean, there's a lot of work that has to happen here. Our colleagues in the Senate will also be working on this legislation. In all likelihood, this will look very different by the time it gets to the finish line. So this is part of that collaborative process. So thank you for being a part of that.
Thank you, Representative.
Yes, sir. Members, we're back in session. We're back on the bill as amended, and I do have a list. Representative Doggett, you're recognized on the bill.
Thank you, Mr. Chairman. My question for the sponsor is, what effect is this going to have on an individual who may be sitting in a local jail awaiting trial or maybe awaiting sentence, and then upon being sentenced, will they be given credit for time served under this?
Leader Lamberth.
Yes, sir. And Chairman, thank you for asking that question. So as a general rule, the courts have interpreted that if we pass a bill that would benefit someone who is going through the system currently, then they get the benefit of however it would help them. And so, yes, if someone is incarcerated, or especially if their case is pending now, and we pass something that potentially could benefit them, then it can benefit them. If it would harm them in any way or extend their sentence in any way from what the current structure is, then it absolutely would not negatively affect them. That's ex post facto. We are not allowed to do that. So if in some way this would benefit them, they are able to take advantage of it. If it would not, then it cannot in any way extend or harm their chances at release.
Chairman Doggett, you recognized.
Thank you. So if someone was sentenced to 3 years and they've already been sitting in a county jail awaiting trial or sentencing hearings for 1 year, then they would have, on that date that they are sentenced, they would know that I've been issued a 3-year sentence. Theoretically, 3 years from today is my X day, or the day that I get out, but I've already had 1 year sitting in a county jail. So I've got 2 years to go. Would that seem right, or am I off the boat there?
Leader Lamberth.
No, sir, I think you're right on the money. I mean, it would give them a very certain time. I mean, their time that they've served gets credited toward either under the current system or the new one. And they get credit for that. And I will tell you, and you know this, I mean, you don't start accruing your good time until you've been sentenced. And so right now, when somebody is someone, and this may be exactly what you're referencing, if someone's in a county jail awaiting trial, they're gaining 1 day for 1 day, but they're not gaining 2-for-1s or good time or anything else. It's just that 1 day for 1 day until after they are sentenced. This bill definitely remedies that, and they will get the time that they have literally served and credited toward their sentence.
Thank you very much.
Thank you. Next on my list, I have Chairman Dixie. Chairman Dixie, you're recognized.
This is my question for the sponsor, and it didn't dawn on me until Mr. White was talking. Is the 1 year is across the board, right? So it doesn't matter the offense or the time served. I think that maybe it's what he was saying. I think that maybe we can take into consideration, because if someone has 5 years and they get a year off, okay, that's 20%. That's a pretty large deal. And I think that what he was saying, he had 25 and he shaved off 3 years, and that made a difference for him rather than those 3 years. So maybe there's some kind of, when he was talking about balance, maybe there's a way that we can look at that. I'm just curious of your thoughts.
Leader Lamberth.
Obviously, we look at sentencing every single year, and as I indicated earlier, I think this highlights where the sentences are, where they have been served. This makes an attempt to put them at an average where they are. I tried in this not to greatly decrease or increase sentences. To get to where that suggestion would be, you would probably need to add on a couple of years. I will tell you, this also alleviates the problem of someone getting a 20-year sentence at 30%, getting out in 3 or 4 years, and then literally having, 16, 17 years on parole afterwards, which is just almost impossible. Someone can then make a minor error, and we've talked about that and debated that in this committee, and wind up going back to prison for a much longer sentence than they ever really should have served. So this brings those sentences within reason, but I tried purposely not to extend the sentences beyond by tacking on additional years. The 1 year, there's also some really good data out there on a lot of the studies that if within 1 year you are not able to reacclimate someone into society within a year to 18 months ordinarily, that's kind of the time period that they're going to violate or mess up. After that time period, it's a graph that just almost plummets with kind of small spikes after that. So if someone's going to be rehabilitated, usually within that year or so afterwards is when they're going to be able to take advantage of that. If they're not, then the same is true. So that year afterwards is purposeful and really based on a lot of the data and studies that have been out there, that a shorter time period for that is better than having someone on parole for like 20 years.
Chairman Dixie.
And I wholeheartedly agree. I've seen people be on, I know a person right now that's on probation for 18 years. The likelihood of making that is probably 0 to 2%. But I just wanted to just kind of reiterate that when you reduce that 1 year good time on a percentage-wise, when you take it across the board, may not be an incentive for other people when they have longer periods. And that's all I was saying, that maybe it's going to be something that's more proportionate. So if someone does get 5 years and that, well, like I said earlier, that 1 year represents 20% reduction in their sentence. And maybe there's a percentage where it's 10% or whatever it is. But then it can be applied across the board. And then I think that'll be have a little more balance in the bill, fair to anyone as opposed to 1 year. And I understand what you're saying about the 1 year rehabilitation or getting reacclimated to the outside world, so to speak. But also, I just want to make sure that it's proportionate, that everyone's fighting for this proportion of good time. And I think from what I'm understanding from what Mr. White was saying, that good time is something that changed his behavior.
Leader Lamberth.
And I should have said earlier, you mentioned something that kind of tripped trigger. I know you've all read the bill and you've seen it in there. We kept in there the 8-year probationary max out. Where a judge can give somebody probation or a 2-serve sentence. They actually have to consider probation first. But with some of these sentences, if they're not at these gaudy and high pretend ranges, if they're really where they're actually serving, some of those E and D felonies are down at 6 months, a year and a half. That's what they're serving. So we did not want to incentivize a judge to not put somebody on probation because the sentence ranges were lower. So we allowed a judge to put someone on probation for up to 8 years, but if they violate during that 8 years, they're only serving the amount of time that is the average range now. So you would get an 8-year sentence on probation, suspended to 2 years to serve if you violated, so that during that 8-year time period, and just like we passed last year, you could work that probationary time period off earlier too. So we tried to keep all of that in there to just avoid the type of circumstance you're talking about where somebody be on probation for 18 years. The 1 year, again, just having spent an enormous amount of time with this, I really think that 1 year is going to work well. And my heart goes out to Jeremy and everybody else that has had to serve through the sentencing structure we have now, because that literally is the only thing they've got going for them is the good time. This can be better and more. I mean, it can give them something where the day they walk in, the whole system's built around. We're not going to just be shocked if you do something good. We're going to structure it so that it's on us. Because right now, y'all, we count on the parole board to make these decisions. We get to sidestep it as the legislature, the executive branch does as well. I mean, this puts it in TDOC's hands, which we fund, we have the oversight on, and we will be responsible for making sure that they have the program available. Because you also heard Jeremy say that many times he didn't have the programs available that he needed. That's unacceptable. We've got to have those programs available. And if they get out without that programming, I want to be crystal clear, it's our fault, not theirs. So right now, there's that release valve, so to speak, where the parole board can look at it and say, well, you didn't do your programming. That's gone with this. The assumption is you have to have the programs available for these folks, and to simply do your time will no longer be an option. You're going to have to do programs.
Chairman Dixie.
Thank you for the response. Thank you, Mr. Chairman.
Thank you. Next on my list, I have Representative Hardaway. You recognized?
Thank you, Mr. Chairman. And I thought I understood the bill until the sponsor explained it. So I'm going to take a shot, Mr. Chairman, with just a couple of questions. What's the role, or is there a role after this becomes law for the probation parole board?
Leader Lamberth.
They would supervise the individuals that are currently on probation, which is an enormous number of folks, and continue to supervise those that are on supervised release under this structure.
Representative Hardaway.
But they would not be responsible for granting or making decisions on release and what time your parole would, there wouldn't be any parole hearings, so to speak.
Leader Lamberth.
Sorry, when you ask about probation and parole, that's under TDOC currently. That would still remain there, and that's who would manage that. If you're asking about what the parole board's responsibility would be, there would be legacy prisoners that they would still be having parole hearings on, quite frankly, for many years to come, that are under the current sentencing structure. So, I mean, they're going to have a job that they need to do, and again, I cannot highlight enough how they do an extraordinarily good job. I have multiple friends that serve on the parole board. We have asked them to do almost an impossible task to look in a crystal ball and figure out, who's safe to release and who's not. We should be making that decision on these sentences, but they do a good job, and for many years will still be needed. Also, commutations and pardons and other, that's what I'm saying, there are multiple types of hearings that they are utilized for and will continue to be utilized for.
Representative Hardaway.
Thank you, Chairman. So I think I'm good with that. So going to the good time, it's built into the sentence. Am I correct on that?
Leader Lamberth.
Yes, sir.
Representative Hardaway.
And the probation, that 1 year probation period, how do we get to that?
Leader Lamberth.
Yes, so probation is built into every one of these sentences. And again, more individuals will be eligible for probation. That's a determination a judge has to make at the time of sentencing, is whether or not someone gets probation or a sentence to serve or some combination thereof. So that will work similarly to the way it does now. The judge has full discretion on that under the statutes that we have. The 1 year supervised release is what would take the place of parole as we see it now, that can only be granted by the parole board. This is 1 year supervised release that is automatic. So they are guaranteed that 1 year unless, again, they do not do their programming or, commit additional crime within TDOC. I mean, it would be up to TDOC who's managing this population on how to manage that particular supervised release 1 year. But it is built in as an automatic unless, again, they do something to lose that time.
Representative Hardaway.
Okay, so the supervised release is built into the sentence. The probation is still in the hands of the judge, so to speak.
Leader Lambert.
Yes, sir.
All right.
Representative Hardaway.
All right, my last question, if I'm summing up the fiscal impact on the state, is it fair to say that there would be a need for adequate funding, possibly more funding, for programming as opposed to prison beds?
Leader Lambert.
There will always be, even under this bill, a need for prison beds. They may look a little different than they do now, but yes, there is additional need for programming dollars. This is an unusual year. TDOC reverted back about $300 million because of some federal funds that came in, but it is not unusual for them to revert back several million. And so we have provided some funding there. We probably should provide some more, whether this bill passes or not. I mean, we need additional funding, and quite frankly, they need to be able to recruit and hire more staff because understaffed facilities, it's very difficult for them to provide the amount of programming that is needed. So again, regardless of this bill, those issues still exist out there.
Representative Hardaway.
All right, and this is just a statement that this bill will help to finally create a true Department of Corrections, with corrections being the key word. Thank you, Mr. Chairman.
Thank you, sir. Any more discussion? Seeing none, we're ready to vote. All those in favor of sending House Bill 1025 as amended to Finance, please signify by saying aye.
Aye.
Those opposed? Sir, you head to Finance.
Thank you, Mr. Chairman, members of the committee.
Thank you, sir. Next on my list, item number 5, House Bill 2098, also by Leader Lamberth. Sir, you have a motion and a second. You're recognized.
Thank you, Mr. Chairman. And it is a very simple and straightforward bill that has been filed many times, but this makes it a felony to assault a law enforcement officer and cause any injury, or excuse me, to cause a law enforcement officer assault and cause any bodily injury. So I'm bringing it up a couple of times because you can assault someone without causing bodily injury. We're trying to focus on the point where someone has not resisted arrest, but literally has assaulted an officer. So walked up and punched an officer in the face, something like that, causing bodily injury. So many other states around us, it is already a felony to assault an officer. It's a misdemeanor here. It quite frankly, an assault on an officer is just like two people getting in a fight, and neither of them are in uniform or on duty. So that's what the bill does.
Members, you've heard the explanation. Any discussion? Any Representative Lamar, you recognized?
Just for clarification, you're saying that they can be on or off duty?
Leader Lamberth.
Now, only in discharging their official duties. So when they're off duty, this would not apply.
Thank you.
Thank you. Any further discussion? Any objection to the question? Seeing none, all those in favor of sending House Bill 2098 to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance. Item number 6, House Bill 563 by Chairman Moody.
Thank you, Mr. Chairman. And members, I know there were several of you that have worked on this, and I thank you for your work, and hopefully this will be easy on my part. But what this bill simply does is it increases the cash collateral pledge.
Chairman Moody, I apologize. I hate to interrupt you. I think what you may be describing is the amendment.
Yes.
And that is
I'm
coded,
sorry.
That's okay. It's coded 4278.
Correct.
We have a motion and a second on the amendment. You're recognized on the amendment. ma'am.
Correct. All right, thank you for catching that. I had it written down and skipped it. It increases the cash collateral pledge for a professional bail bondsman from 10 times to 20 times capacity.
Members, you've heard the explanation. Any discussion? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 4278 to House Bill 563, please signify by saying aye. Aye. Those opposed, you adopt. We're back on the bill as amended. The amendment made the bill. Any further questions for the sponsor? Seeing none, all those in favor of sending House Bill 563 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Ma'am, you head to calendar and rules.
Thank you.
Thank you, ma'am. That brings us to item number 7, House Bill 1963 by Chairman Doggett. Chairman Doggett, you're recognized. Sir, you have a motion and a second.
Thank you, Mr. Chairman, members of the committee. What this bill does right here is currently the TBI maintains a drug offender registry. This bill would remove those names of the registry that have deceased, and it also requires the TBI to verify that through death records or other means.
Members, you've heard the explanation. Any discussion? Seeing none, all those in favor of sending House Bill 1963 to calendar and rules, please signify by saying aye. Those opposed? Sir, you head to calendar and rules.
Thank you very much.
Members, that concludes our business for today. Thank you very much for your hard work, and we will see you here next week. We are adjourned.